There was a little bit left. I disposed of the tray.
You what?
I used it.
And you used it. Then okay, so it didn't stay on the tray.
Right. And I disposed of the tray.
Yeah.
Yeah, Jonathan, on behalf of the people.
Court shall feaster Assistant Public Defender, Mr. Walter LaCroix. Mr. LaCroix, please state your name for the record. Walter LaCroix. Thank you, Judge. I have spoken to Mr. Edmonds about this case. It's going to do some further look at the matter to see where we stand in terms of an offer.
Buckle up, guys. Today we're diving into a courtroom moment that starts quietly, but quickly reveals the tension underneath. In this opening stretch, the judge begins sorting out basic details. Attorneys introduce the case. And what seems like routine procedure slowly hints at something deeper. You can feel the pressure rising even before the real confrontation begins.
We're asking just for an adjournment for a couple of weeks of the PCC. And then I need to address his, it's not a bond violation yet, I don't believe, but it's a bond report where Mr. Croy given permission to test in Genesee County. He signed up for a program, DNA testing in Genesee County. That program did not release testing results to the community corrections unless he was
positive. Hold on a second. That's not what I have. Do you have his progress report?
The one that I have, I do have a progress report. I don't
from August 28th.
I don't believe that's the date. Let me check.
Mr. Allen.
Yes, mine dated August 28th.
In terms of his testing, I have on. So he's here on an operating while intoxicated causing death.
That's correct, Judge.
All right. And on August 20th, after his arraignment, what day was he arraigned?
I believe he was arraigned on the 16th.
So then he got tested on the 16th he was ordered. He wanted to test there. He tested on August 20th, and he's positive for cocaine.
Correct, Your Honor. I'm aware of that.
Then, on the 22nd, he didn't appear for his testing.
That was when I was setting up to be tested in Genesee County. I didn't have to test again because I had just tested.
In this segment, the judge digs into the defendant's testing record and discovers a cocaine positive result. Just days after his arraignment for causing a death while intoxicated, the room tightens as the judge questions missed tests, shifting explanations, and the defendant's choices. What began as mild inquiry becomes a rising storm as the truth starts slipping through cracks in real time.
I was just signing up to test in Genesee County. And I called the lady down here to let her know right away.
All right. Let's go back a moment because I don't think he's been before me.
I don't believe so, Judge. Just asking for a 2-week adjournment to see where we stand in terms of the potential.
Why is he testing positive for cocaine after getting charged and arraigned on an operating while intoxicated causing death?
Because he used cocaine, Your Honor. Obviously. I don't think he's.
No, it's a fair answer to my question. I'm just saying why.
Yes, Judge.
Why? I mean, why is he using anything?
Well, my understanding is he is not any longer.
What?
My understanding is he is not any longer, but he previously was. He began testing.
Asterisk, here's where everything erupts. The judge presses the defendant about his bizarre claim involving a cocaine tray, and the story unravels fast. Every answer contradicts the last, and the judge's disbelief turns into sharp frustration. This back and forth exposes the defendant's evasiveness, and the courtroom shifts from confusion to outright confrontation as the judge tries to pin down what really happened.
Transferred that testing to Genesee County per the instructions he was given at arraignment. He's been testing there, but they are not reporting the results here unless he is positive. They have not called him to test this week. He's called them twice a day to go test. They have not called him, so he went over today to community corrections and tested here. And he is going to change if the court allows him.
Tested here today?
Here this morning.
What did it, do we have results on that?
I don't have it.
I don't have anything yet,
I was
Judge.
informed about it this morning myself.
So, go ahead, Mr. Green.
Thank you, Judge. So rather than do the Genesee County testing that authorized to do that does not send the reports as community correction would require, he has signed up again today to test here and do all of his testing here, although he does not live here. He has a relative here with him who has agreed to drive him back and forth. To do
Okay.
that testing, if he is allowed, Your Honor. I understand.
What was the intoxicant in the primary offense?
Okay.
So let me get this right. He's charged, I just want to make sure. So I have it clear in my head.
You do.
He was charged with operating while intoxicated, causing death.
Yes, Your Honor.
The intoxicant in that charge is cocaine.
Yes, Your Honor.
He's in arraigned. So now he knows what he's charged with.
Yes.
He's told to go to community corrections. When he gets to community corrections, mind you, 4 days later.
Asterisk, this part shows the judge reaching his breaking point. After reviewing new test results, he confronts the defendant for insisting he isn't using while evidence says otherwise. The defense tries to soften the damage, but the judge's patience snaps as he calls out the dishonesty directly. The tension becomes unmistakable as the courtroom struggles between excuses, truth, and accountability.
Yes. He tests positive.
He tests positive for cocaine.
I had some at my house, which I disposed of.
In your nose or what?
I had it in a tray and I disposed of it.
You what?
I had it in a tray
And then you just smoked it.
I threw it away.
You threw it away? How's that work? Where did you throw it? It's gonna be a long conversation. Where did you throw it away?
There was a little bit left. I used
I
it.
know.
I disposed of the tray.
You what?
I used it and then
Oh, you
disposed of the
used
tray.
it. Then, okay, so it
There was only a
didn't
little
stay,
bit.
it didn't stay on the tray.
Right.
And I disposed of the tray.
Yeah. Yeah. Okay, well.
And since then, I haven't touched it since.
What's that?
Okay, he probably stopped using because he was coming today. And yeah,
I'm printing them now.
you're printing them. So somebody needs to answer for me, why was he using after being arraigned
I mean, I was,
on this charge? And why was he using?
I
I
don't,
have my theory, Your Honor.
I don't think there's any answer to
Oh, darn.
satisfy the court as to why.
And by the way, you're still using.
Honestly, I don't see. I
Oh,
have,
really? Hold on.
I've never
But you
worked
know
on
what?
it.
The thing I hate more than anything is when somebody lies to me.
Honestly, I'm not.
Okay. We'll just make sure that you, because it has to be in your system in order for you to test positive. And if you get that experience, fine.
Counsel, approach briefly. You want to see this? That's my copy, though. Yeah, this is the one he took today. No, not at all. We need all of this on the record.
And the last positive, from the second to 7 days later.
Yeah. 7 days later. And a little bit he threw away.
Okay.
That, go ahead, I'm sorry. I'm messing up your story.
Oh, I know. But all I've done is I've used it in the chair that I saw. I've used it. That was it.
When it's second.
Well, no, I have not.
Okay. Well, we'll tell them that, but you know, medically.
I know. I didn't. I want to do this. I want to hear the truth.
Okay.
'Cause my-
To answer your
my
previous
conscience is not
question,
allowed.
Judge, why?
Oh, he's positive for cocaine.
Judge. And
Just so that we know.
thank you, Judge. And to answer your previous question as to why he's still using after being arraigned,
Sure.
clearly he has a problem, Your Honor. There's no answer I can give you that can justify use of cocaine after arraignment when it's an illegal. He doesn't have any type of special license to allow him to use cocaine, Judge. So clearly, has a problem. He is willing to address that problem when he's testing there. He is working, and he did voluntarily come here today and take a test. So he's asking you to
Not saying that, right? No.
No, you have to say.
Right, anything else?
All I can say, Your Honor.
Tell you the truth. Okay. My cousin doesn't allow anything.
There's no way to put it in your food or drink.
It's possible. I have friends from my mother's house where I'm cousin's house to do work down there. Okay. Because I'm gonna eventually reside down at my cousin's house.
All right. So to the positive test, Your Honor, I have no explanation aside from what he already told you.
Which positive test?
The
First one or this one?
The first positive test. Your Honor.
Oh,
The
okay.
explanation he gave you is that he used it and then threw away the tray. After he was arraigned, after he was ordered not to use, have no explanation, Your Honor. He'll just ask for mercy from the court on that, and he is willing to get any treatment that the court would allow him to take place.
Except that he can't follow the court's order. I don't know how he's gonna do treatment. And the other thing is, he doesn't test when he's supposed to test.
Yes, Judge.
So it seems to me I have two options. I can let him go and say, oh, well, best wishes. Or what I can allow him to do is go back out there, use some more cocaine and kill somebody else. I'll let you know. Not doing it.
Understood, Judge.
Defendant's bond is revoked. Defendant remanded to the Washington County Jail. I'll set his hearing September 12th, 2024, 9 a.m. for probable cause.
Asterisk, the final stretch hits with full force. The judge lays out the stark possibilities. Let the defendant walk free and risk another tragedy, or revoke bond to prevent further harm. His frustration peaks as he rules that the defendant will be taken into custody, ending the hearing with a decisive, sobering conclusion. If you found this breakdown valuable, make sure to like the video, subscribe to the channel, and we'll see you in the next video.